Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. I'm looking today at a book from Oxford University Press. It's one in their series. It's Market Abuse Regulation, Commentary and Annotated Guide, and it's been edited by two people, Marco Ventoruzzo and Sebastian. Now, the book has come to us, as I say, from OUP, and Elizabeth and I talked about the book, and we've given it a title for our review as follows: A Book for Our Time, Fresh and Erudite Discussion on the European Union's Market Abuse Regulation. Now, I know we're going to leave the EU and all these things are going to happen, but it's a long way off, and this book is very important from a number of points of view, because in the short term we've got to be very well aware of what is going on and what's going to happen. So let's have a look at the book. There are going to be a lot of these books around which will be valuable for a very long time to come. Here's the front of the book, there is the spine, and then there's nothing on the back. Okay, now if we open it up, it's a hardback. Just go to the back of it first of all. You can see that the index is by paragraph numbering. Section and paragraph numbering, so it's very well organised, and you should be able to find what you're after quite quickly, and it does show you the index there. And then after that you've got various reports and various matters right at the back of the book, but at the front of the book, let's look at the front page first of all. There we go. And after that there is in fact a nice little dedication which I'll just let you read there. It's always important because I think it's very useful for people to know that they're thought of when these books are produced. That is the information which is well worth reading in the main preface at the beginning from the two authors. They start off by saying the Market Abuse Regulation, MAR, is one of the centrepieces of the new Capital Market Union, the CMU of the European Union, EU. So these are a lot of abbreviations right at the beginning. But the important thing is this is a very important book for anybody involved in this area. There is the contents section. As it's an annotated guide, it gives you a whole series of guides and commentaries throughout. And it's looking very much at here at specific articles, as you can see. Again, disclosure is covered. A large amount of stuff running all the way through. Then you get after that, you get right at the back, you've got Article 38 and Article 39 included at the back. You've then got the table of cases, and of course, as usual, you've got cases based on UK, Court of Justice of the European Union and so forth. Not a lot of case law. You've also got cases from other jurisdictions. You've then got the legislation, which is there. And then after that, what we have got is abbreviations and legislation as well. That is always useful because, as I indicated right at the beginning, there are a lot of abbreviations. And it is quite useful to know what they mean, because sometimes it's not easy. This has been edited by two people, so there are a lot of people who've been contributors. I can't go through all the names, but there are a large number of people mentioned there, and I'd like to thank all of them very much for the work they've done. Then we get into Part A, which is the guide itself. You can see there's an index to the chapter, and then you've got paragraph numbering at the sides, and you've also got footnoting. So you run through and you can see all the way through that that's how the structure of the book works. And you should be able to find what you're looking for quite easily. As I say, you've got right at the back the provisions, final provisions of Article 37, and then you've also got, in addition to that, Article 38. And the book runs to about 500 odd pages. So what do we think of this book? Well, this is what we say. We say, balanced against the myriad advantages of a free market economy, there are inevitably a number of downsides, most or all of which come under the category of market abuse, an important area for all of us to consider. And within this bleak landscape, the need for market abuse regulation, that's MAR, yes, it's capitalised, looms large. So if you are in any way involved in matters pertaining to financial services, specifically within the European Union, this new practitioner's text from the Oxford University Press is what you need, the subject matter being more than a little complex, to say the least. And I have to say that when I was studying this subject, actually for the bar exams, a very long time ago now, I did find it quite confusing then. And whilst I'm relatively up to date with a lot of the information, it is still quite confusing. So don't expect yourself to be an expert immediately. This book, of course, will help you immensely because it offers an interesting historic perspective at the outset of the discussion, and the two editors, that's Marco Ventoruzzo and Sebastian, point out that the regulation of market abuse has a long history in the European Union itself, dating back to the 1960s, when of course it was the common market, following on, as you might say, from the initial efforts in the United States to impose regulation against insider trading as a result of the 1929 stock market crash. So it's got a historic background to it. Now in Europe, a number of directives were launched from the 1960s onwards aimed at curbing market abuse. Notably, the Market Abuse Directive, MAD, which has now been replaced by the regulation as opposed to a directive, namely the Market Abuse Regulation, MAR. So I hope that is absolutely clear about where we are now with regard to this subject, around which, of course, the discussion by this book's expert contributors ultimately revolves, and they have brought together the leading experts in this field. Now, MAR, as the editors explain, is, quote, one of the centrepieces of the new Capital Market Union, the CMU of the EU, which is the statement right at the beginning of the preface, with far-reaching significance for law practice and research. And the hoped for outcome is that it may lower the barriers which too often separate jurists from different countries within the EU. Whether this development will smooth the path to eventual harmonisation of European Union law remains to be seen, especially with the decision by the British to leave the EU. Although the editors, together with their several contributors, support the view that continental Europe now speaks a common legal language in the area of market abuse. And I wouldn't have thought things will change that much, frankly, because common sense dictates that as much as anything else, because it's all about, at the end of the day, it's about advantage and the way some people should not be allowed to behave, because it's clearly unfair, inequitable, whatever the words are that you use, is not fair on the others, putting it in its most simple way. So the point is that in the opinion then of the authors and the editors, it's a major step forward towards a more uniform legal framework. That has been always the aim. It's been the aim of why I've always been a supporter of trying to get some harmonisation across the whole of the European Union. The fact that we're leaving is not going to change that, in my view, at all. But we'll have to wait and see on that one. Now, market abuse manifests itself in various ways, the most pervasive of which are discussed in the book. And the annotated guide section, which is section A right at the beginning, deals in detail with, for example, insider dealing and market manipulation, examining basic concepts as well as possible remedies available within public and private enforcement of market abuse regulation. And in the second section, which is section B, the book's expert contributors come into their own, offering a number of viewpoints on market abuse, which I think are very helpful. Particularly interesting are the subsections on insider information, including unlawful disclosure. Another section deals in detail with ESMA, which is the European Securities and Markets Authority, and the various issues involved in whistleblowing mechanisms and the whistleblowers themselves. And of course this tends to be, in fact, very topical at the present time. Now, international in orientation, this book nonetheless appears not to have mentioned Brexit. I can hear a lot of people breathing a sigh of relief. It can't be too far-fetched, of course, to conclude that as far as the contributors are concerned, Britain's planned exit from the EU on the 29th of March 2019 is probably an irrelevance, considering London's international preeminence in financial services. This is not a terribly comfortable assumption, but we have to wait and see what happens. I mean, it really is as simple as that as time moves on. I'm recording this with a long way to go. It's late spring, so we've still got about 10 months to go before we actually leave. Let me conclude by saying this, that financial services practitioners, we think, will be interested in inquiring this book, with its range of perspectives on regulation in general and the EU market abuse regulation in particular. And researchers, of course, from a wide range of professions will certainly appreciate the wealth of research references offered throughout, especially in the extensive footnoting and in the tables of cases and of legislation. There's a lot of detail here. And the law is stated as at the 1st of September 2017. Let's just have a look at the book again. There it is. It's a heavy book actually for what it is. There's the spine, and then there's nothing on the back itself. But so say it runs to 550 odd pages. This is part B, which I talked about. This is the annotated guide by the experts. You've got the paragraph numbering at the sides, and you've got a lot of footnote detail, which is very helpful. And if we go to the front bit, this is part A. The concept of insider dealing is dealt with right at the beginning. I do think that's important because I've said it in other reviews that I've done. There's a paragraph number you can see again on the footnote. The point I would make about insider trading is that it isn't right. It's as simple as that. And there are some people who think it is right, and they're wrong. And it's really as simple as that. But I'm glad that the statement is made, because there's still people around who don't seem to think that there's anything wrong with insider dealing. And of course there is a lot wrong with it, because it's unfair. And that's in its simplest form. We've got to have the level playing field where everybody is basically equal. Otherwise it does lead to abuse extremely quickly. Big thank you to the authors and OUP. And watch this space. We have no idea what's going to be happening in the next few years with either the European Union or Britain's link with it. But in the meantime, we have these excellent books from OUP. And I'm very grateful to everybody concerned for the work they put in with this particular book. Thank you. Bye-bye.